Hey, Pete.
Hey, Dave, how you doing?
Good. So just so you know, I got a requirement now, I guess, to put these meetings live on YouTube and then do this closed caption thing too. So it's being recorded now.
Okay, well, that's all right. That's it should be recorded, so that's
Yeah.
good.
So a few folks on.
Maybe there's one or two other Yukon fans on the commission who will be willing to.
This thing moving?
Yeah. If my son's dopey dog starts to bark, I'm going to have to go get him. He's outside.
No problem.
He's a loud bark. He weighs 200 pounds.
Oh, geez. What kind of dog?
Newfoundland.
Oh, wow. Okay.
Dave, you hear me?
Yes. Can you hear us?
Okay, yep, I'm here.
All right. Yeah, your video, you look very bright. It's not just the beard, the lighting
No, I put the light in the back.
is.
Signed on, it was, oh yeah, it still is, huh?
Yeah.
What happens if I shut it off? Hold on a minute.
Here you go. That looks pretty good.
Better?
Yeah, that's a little better.
Good. I turned on my wife's computer lamp.
John, can you hear us good? Hey, John.
Hey, Dave. Hey, Pete.
John?
How are you?
Yes,
Oh, John,
Don, how are you? David, you look great.
oh, still growing.
Yeah, I haven't shaved in about four or 5 weeks, and I can't stand it. I gotta,
No, me too. I was talking to that.
as soon as I go back to work, it's coming off.
The trouble is, it's so long in here, I get it in my mouth when I eat.
Yeah, exactly.
I'm gonna go transition. I'm gonna take it off the side and go
Right.
handlebar mustache,
Right.
and then I'll shave it all off. Peter, this is just my winter foliage.
Good for skiing.
It's your mask. It's your natural
Right.
mask.
There you go. Makes sense.
Hey, Pete, how's Ira?
Good.
What's
Is
that?
it good? Tell
Yeah,
myself hello, please.
I will. He doesn't come into the office. He stays home and works from home.
Yeah.
So some of us go in, some of us don't.
Yeah, that's kind of how we are. I think we're,
Yeah.
I was in today. I probably will go in tomorrow after our staff meeting, and then I go in on Thursday, probably not on Friday because I'm getting my second COVID shot on Thursday. So I expect to be,
Did you get the Moderna shot?
I got the Moderna, yes.
Yeah. So there's a likelihood you'll have a reaction to that. With
That's-
Pfizer, the second shot doesn't generally result in a reaction, but Moderna
Oh, that's
shot
interesting.
generally does. Not for everybody, but it's much more common in Moderna than it is in Pfizer.
Oh, that's interesting. Yeah, I've been warned, basically, but yeah.
Kathy and I have both have had both of our shots. In fact, Kathy had hers this morning, and there was no reaction whatsoever.
Were those Pfizer?
With Pfizer, yeah. Just
Yeah.
a little pit, like a flu shot in your
Right.
muscle. That's all.
Was it the Pfizer shot, David?
That's Pfizer, yes.
Yeah, yeah. So I'm not so I'm expecting a little bit of a reaction.
Well, you have Pfizer though, John, so probably not.
Well, I have Moderna.
Oh, you have Moderna. Okay,
Yeah.
yeah. Well, then yeah, you probably will. Mine's Moderna too, but I don't get my
Thanks,
second.
Pete.
Yeah. Well, I have the same thing. I don't get my second shot for a couple more weeks, but yeah, my wife had it and she had them both. She definitely had a reaction after the second shot
With Moderna.
with Moderna.
Yeah, that's interesting. Yeah.
Yeah, it was not a terrible reaction, but it was 12 hours of fever and chills and body ache, and then it went away
Yeah,
almost as fast as it came on.
yeah, that's what I hear. Dave told me to take Friday off, so.
I think that's a good idea. In any case,
I have to leave for 1 second and bring the dog in. I hear him barking.
All
Right.
right.
I hear him also. Hello, John.
Hey,
Hi,
John.
how are you?
Good, good.
Kayla. Hi.
Oh,
Are these all the people we're expecting?
Bob's on just now.
Bob's here.
And is Joe?
Yeah,
He
we did I
responded
think
that
everyone
he's-
responded, Kayla.
Okay. So, I don't know. Should we just get started?
This is Ed Zimmerman, the applicant. I don't see Steve Sullivan on. I think we might need him if there's some questions.
He just got on, Ed. He's on now.
He's
Oh,
jumped
good.
on since I checked last. All right, thank you.
There's Bob.
I'm here.
Okay. So I think it looks like we have everybody that we expected. So I think our only agenda item is our discussion with Mr. Gelderman. And this, as everyone who's at the meeting, this is so we can answer the questions we had about this application and our responsibility and expectations with respect to, what is included in a subdivision application, subdivision referral. So
This is
I
more of a generic thing rather than specific to shoreline. That,
I didn't hear the question.
are we talking about something more generic with regards to the referral, or are we talking about the application itself?
Well, I think that's a good question. Given everybody who's on the call, I guess part of this will be to the application, but obviously, and Mr. Pete can guide us, but I think, this will apply more broadly than just this application. I think this particular application, given how complex it is and given how many different wetlands are involved, I think that's partly what has raised so many questions. That is my sense from our meetings on this thus far. So, Dave or John, Delora, I think, should we just open it up for go ahead.
Kayla, two things. One, I guess if there's so many people on the call, if you're not talking, it'd be good to mute yourself so we're not getting any feedback. And I'd suggest that we start, I think Pete's prepared to give you an overview of his position regarding the process. And then I think the agency members should have a discussion with Pete about that, ask questions, have a dialogue about that. And then depending on the outcome of that discussion, there may be a need or interest to discuss further the specifics of this application. I think maybe starting with Pete to provide you a little bit of background on his legal opinion on it would be a good place to start.
Okay, I'll start then. Let me start by saying, well, first of all, good evening, everybody. Some of you don't know who I am. I'm Pete Gelderman. I'm with the law firm of Bircham and Moses, and lawyers in our firm basically represent the town of Madison, and I happen to do a lot of the land use related stuff for the town. So planning and zoning and wetland related stuff, that's where most of my background is. So first, let me say that the statute that requires the Inland Wetland Agency to review a subdivision application where there are wetlands involved or a water course involved in the application is 8-26 subparagraph E. And basically it says that if an application involves land regulated as an inland wetland or water course, the applicant shall submit an application to the agency responsible for the administration of inland wetlands no later than the day the application is filed. And then the commission, when it says commission in the statute, that means the Planning and Zoning Commission. When it says agency, that means the Wetland Agency. So the commission is supposed to still decide its subdivision application within the required timeline. The commission, however, cannot make a decision on the subdivision until the Wetlands Agency has rendered a report to the commission. The commission then is obligated to give the report what the statute calls due consideration. So a couple of things are come up with that. First of all, it's unfortunate the statute is not drafted particularly artfully. And it, even though the case law has kind of made a determination that 8-26E is clear. I'm not actually 100% sure it's that clear, but the bottom line is there are cases that refer to 8-26E and talk about how it what the interplay is between the subdivision application process and the wetland agency process. And the first thing I'll do is going way back to when the statute was first adopted. And that was initially discussed in 1977, but it's been modified several times since then. But going back, and legislative history is something that only theoretically gets discussed if a statute is not clear. But legislative history was discussed in a recent case that was decided by Judge Berger, who some of you may know is the land use was and still, he was the presiding judge for the land use docket for the state of Connecticut. And he's now retired, so he's not the presiding, he's a judge referee right now, so he's not technically a full-time judge, but he still hears a good majority of the land use cases that come up. Anybody who has a complicated land use case can refer their case up to Judge Berger in Hartford, and he will hear it. And I've been before Judge Berger dozens of times. He's a really good judge and limits himself to land use. So in a recent case called let's see, it's called the Coalition to Save Easton against the Easton Planning and Zoning Commission. A situation came up where there was a subdivision and it had to be referred to the Wetlands Commission. And without getting into a whole lot of detail about the case itself, eventually there was a question about whether or not the wetland agency needed to, what their role was in this. There's a little bit of factual difference in that case with this matter. In one sense, in another sense, there's a similarity, because what happened in this coalition case was that a subdivision application had been made 4 years prior. The wetland agency had written a report and given it to the Planning and Zoning Commission. And then the application was modified several years later. The applicant in that case made a determination that it really wasn't much of a change, and decided that it didn't have to go back to the wetland agency for a new report, that it would just rely on the report that the wetland agency issued 4 years earlier. Well, the court, Judge Berger, determined first that that's not the applicant's call, that's up to the commission to determine, the Wetland Commission to determine if there needs to be a new report based on the conditions that existed. But that's not really why I'm citing the case as much as I am for the legislative history that Judge Berger cited. What he says is he quoted a representative who was around in 77 when the act was initially being discussed, and her statement was, if talking about the purpose of adopting that language, said if the proposed subdivision site is located on land regulated under the inland wetland statutes, the applicant would file a copy of his application with the agency enforcing the inland wetland and watercourse regulations. At that point, it was within 10 days. Now it's prior to. And she went on to say, this way the applicant would not, as some have, go through the entire subdivision procedure, get his approval, and find he could not get a building permit because he needed approvals from the wetland agency. So the history of this was that a copy of the subdivision application would be provided to the Wetland Commission so that you'd have exactly what the Planning and Zoning Commission had in front of it. You'd review it and you'd make a report to the Planning and Zoning Commission. And elsewhere in Judge Berger's decision, he states, for example, that he says the referral process, he calls this a referral process, was not meant to give the Wetlands Agency veto power over a proposed subdivision application if the land to be subdivided contains inland wetlands. The ultimate authority over approval of the subdivision rests with the commission. That means the Planning and Zoning Commission. And any regulation or statute that abrogates that authority is not valid. So what Judge Berger was recognizing was that the Inland Wetland Agency, their report is not the Planning and Zoning Commission, I should say, cannot deny a subdivision application based solely on the report of the Inland Wetland Agency. They have to make their own determination. There's other cases actually that talk about that as well. So it's not up to the Wetland Agency to say this subdivision is no good. It can't, there are too many wetlands, there are too many issues. The agency, the Wetland Agency's obligation is to review the application and file a report with the Planning and Zoning Commission. The Planning and Zoning Commission cannot approve or deny or act on the application until they get your report. There are no time limits on your report. So it's simply a question of giving a report. Now, sometimes when an application for a subdivision is filed, it contains activity that by definition is regulated activity. For example, a road. Some subdivisions contemplate building a new road. In fact, this property initially had an extension of Maplewood Lane, I think, Dave, is that right? Maplewood Lane, into a cul-de-sac that was located within a regulated area. So the applicant in that case filed an application with your commission to conduct a regulated activity to build that road, and also to build an access way across wetlands. That was it. Also then had its application referred to you for purposes of a report. So back then, this commission had applications pending in front of it for regulated activity. It acted on those, and then it also issued a report to the Planning and Zoning Commission, which are mutually exclusive functions of the Wetland Agency. So, and in fact, in the appellate court case that heard this, it was back in 2013 when that case was decided by the appellate court. It was called Robert Weinstein and others versus the Inland Wetland Agency of Madison and 107 Longshore Lane LLC. Those were the parties. And the court in that case said, and I'll read right what it said. It said, in connection with the subdivision, well, let me go back a little bit, read the whole sentence so it makes sense. It said Zimmerman submitted an application for the approval of 2 regulated activity permits in connection with the subdivision. One, the construction of a cul-de-sac, which would involve filling a wetland, and the construction of a road within 100 feet of a wetland. And 2, a wetland crossing for a driveway access to one of the proposed lots. Zimmerman also sought a subdivision referral to the Madison Planning and Zoning Commission. He did not seek regulated activity permits to develop the subdivision's individual lots or to make theoretical improvements to Longshore Lane. So in that case, there was a specific application filed to the agency, to you guys, and you acted on it. There was a separate referral for a report to the Planning and Zoning Commission, which you also gave. There was not a request for permits to do any work other than the road and a crossing in the subdivision. So all the houses and everything else were not part of an application that was pending at that point in time. So the bottom line is that when there's a subdivision that has wetlands on it, unless there's an application that's filed to conduct a regulated activity, the commission, the agency's role, your role is to review the subdivision and render a report to the Planning and Zoning Commission. In an ideal world, that report would point out that there are wetland issues, watercourse issues, whatever they happen to be, and that future development of the lots will need to come back to your agency for approvals, for review and approvals. And the report should state that, until those approvals and permits are obtained, there's no, the developer, the owner doesn't have any right to necessarily develop those lots if they involve regulated activities down the road. So there are really two distinct functions that you have. You only have one, as I understand it right now, because nobody has filed an application to conduct or to perform any regulated activities yet. Obviously, the subdivision, before it can be developed, will need review and approval from you guys, because as I look at the map, it's hard to see how this subdivision can be developed without encroaching into regulated areas and therefore regulated activities. So now, one other thing that just to draw a little bit of a distinction, there's a similar language to the subdivision language in the statutes when it talks about site plans, that if a site plan involves a regulated activity, it has to be referred to your agency as well. But in that statute, unlike the subdivision statute, it says if a site plan application involves an activity regulated pursuant to sections 22A36 to 22A45, which is the Inland Wetland and Watercourses Act, the applicant shall submit an application for a permit to the agency responsible for administration of the inland wetland regulations. So there's an actual application that has to be filed. That's not the case under 8-26E. Certainly an applicant is entitled to file an application for regulated activity if it chooses to do that. And in the case of the prior application with respect to this property, there was regulated activity that the applicant determined he wanted to see if he was going to get it approved or not. And that primarily was the road and a crossing. So, so I guess the bottom line is that, and by the way, I've spoken to Tom Crosby and I've spoken to Eric Bernheim, mostly Eric Bernheim, about this in some detail. I don't know if Eric's on the call tonight or not, but he and I disagree, and Eric and Tom are good lawyers, but I'm giving you the opinion that I think applies here. And, unlike Eric and Tom, I don't have a dog in the race. I'm trying to advise the Inland Wetland Agency the best way I can. I don't have a client who's seeking to get something done or oppose something here. So I don't have any particular bias. Having said that, what I say to you guys is my opinion and my guidance. What you do with it is up to you. I mean, I can't tell you to act or not act in a certain way. That's part of your job. But as I read the statute, your function now is to having had, let me back up a second. I understand also that there's a technical issue here, and that is that the statute that talks about subdivision regulations says that an applicant shall submit an application to the wetland agency. Under the sort of legislative history that I talked about, that would have been a copy of the subdivision application. I understand that here, the applicant didn't submit that application. Dave did on behalf of the Planning and Zoning Commission, just referred it over to you guys. So there may be a technical issue there. I don't think it's substantive. I think it's procedural. Either way, you get the you get the application in front of you, and once you have it, you would review it and give the commission, the Planning and Zoning Commission, whatever information, advice, observations that you decide you want to give to them, and then they can give that due consideration. So I think that's about it.
Thank you. That is good. And I think that's pretty clear. I have a big question, but I will let other agency members go first. I can save mine. So I think we're at a point where it'd be great because there were so many questions from the agency members. So I think you guys can go ahead and ask Pete.
So if I could I chime in, Gil? Thank you, first of all, for coming. I know it's, I'm sure you attend a million of these meetings, but I felt like we really needed your advice on this. So I had questions which you, through your talk tonight, definitely got answered. So we're to give a report, and I'm, at some point, maybe now's not the time, but later on in tonight's meeting, if you could take us through, since I've been on the commission about 6 or 7 years, I don't think we've ever had a report that we have to do like this. So could you take us through the mechanics of it, or maybe Dave Anderson could, as to how, we would put this together? What do you see as the normal mechanics of it? In other words, do we get together and do it tonight? Do we do it as an ad hoc subcommittee? How do we present it so we do it properly from your experience?
Yeah, that's a good question. Sorry, go ahead.
And I guess the only other big question I had is as you mentioned, there's a question of the applicant, but I also thought there was a question as to ownership as to part of this, and I don't know how that would impact it, if that's also something we just report and move on, or that's something that abutters will bring up, or, is that out of our jurisdiction or not? Those are the two basic areas. You answered one of them on the applicant, the technicalities and the process, but there's come up an issue of ownership, and do they even have the ownership interest to make the full application? I know that attorneys will disagree as to who has what, but I'm concerned about that, because if we incorrectly move it along without the proper ownership, is that an issue? That was one of my concerns. Thank you.
Well, I'll answer the second one first because it's a little simpler. Ownership is generally not something that that land use boards get involved with necessarily if there's a dispute about who owns what. Here, the application itself is the area that's within the boundaries of the property, not the road, not shorelands, not longshore. Those are not those roads. While they are going to be required for access, or possibly required for access, they're not part of the application. They're not, so the town doesn't need to be an applicant. The owners of shorelands does not have to be an applicant. Anybody else who has an ownership interest in Longshore Lane does not have to be an applicant. With respect to how the process, how you go about doing this, there's no guidance in the statute, but the way it usually works is after the agency has reviewed the map and you've discussed it among yourselves, you come to a consensus as to what your issues are, what your observations are, and what things the agency as a whole, meaning majority, think that they should present to the Planning and Zoning Commission. So it can be as detailed or not detailed as you deem it necessary. It can be, the report can have bullet points. It can be written in prose. It can be whatever the agency decides is the best way to let the Planning and Zoning Commission know what your concerns are with respect to this particular piece of property going forward. Keep in mind that eventually you may get an application to conduct a regulated activity for some of this, for any or all or whatever on this property. What you don't want to do is have so much detail in your report that it looks like you've prejudged any application that may come before you, because you don't have a lot of the information that you would need to issue a permit, to grant a permit. I mean, there's all kinds of information that you're going to need before you're going to be in a position to grant a permit for regulated activity. I don't know, what all that will be, but I'm fairly certain you don't have it in front of you yet. So you'd have to, your comments will be based on the information you have. You can look at the map. You can say, we anticipate that, this could be an issue. This is going to be a problem. We don't see how this lot is going to be able to be developed without a significant impact to the wetlands. There may not be a feasible and prudent alternative. You don't even have to get into feasible and prudent alternatives in this report, but the idea is that the report can be something that you vote on it as a group at the end of the day after somebody kind of writes down what it is everybody wants to say, and you vote on it like any resolution that you have. The only other thing that's kind of comparable is the Planning and Zoning Commission has to do something called an 8-24 report sometimes when there's not sometimes, but whenever there's a municipal improvement that's proposed, they have to issue a report. And what they usually do in that is they sit there, they talk about it among themselves. You don't have to, this is, it's the report stage of this. It's not a public hearing. It's up to you to, I understand you've let people speak, and that's fine. There's nothing wrong with letting people speak, but it's up to you guys to decide how you want to do this. And the simplest way is to have a discussion and just go around the table or around the town, as the case may be. Everybody gives their input, and at the end of the day, someone summarizes it and says, what do you think?
Pete, I have a question. A large portion of this property is tidal wetlands versus inland wetlands. And the DEP has jurisdiction over the tidal wetlands. We do not.
Correct.
Should we restrict our comments to just the inland wetlands or in general?
Well, you should restrict your comments specifically to inland wetland and water courses, but it's not inappropriate for you to say there are tidal wetlands there. In addition, there are tidal wetlands on this site that will be, that fall under the jurisdiction of the DEP. And this report is not intended to comment specifically on areas outside of our jurisdiction. But so really your comments relate to inland wetlands and water courses.
That was my point. And the
Yep.
second thing that I had, and I brought this up in the meeting the other day, there are proposed lots that do not have access. And if the planning and zoning allows those or separates those and designates them as lots, aren't we behind the 8 ball and having to approve something to access?
No. Yeah, no. I'm sorry, I didn't mean to interrupt you, David, but
Oh, it's okay. Yeah.
But the answer to that is no. It doesn't mean that somehow you've given something up. You have the same rights as you would have if this subdivision had been created 20 years ago and someone wants to conduct a regulated activity. One of the reasons that the report is important is because it will give a property owner, a developer, some idea of what they may be up against, what the issues are, what the concerns are. If a developer chooses to subdivide the property in a way that creates lots that either aren't developable or don't have access or whatever, that's the developer's issue, but that doesn't tie your hands down the road to require, that some activity, there are some lots that can't be developed. And, in the world of takings, condemnations, inverse condemnations, which eminent, people get concerned about, well, if we don't let them develop it, is it going to be a taking? Are we going to have to buy the lot? The answer to that is no. There are lots of cases on that. If some lots just cannot be reasonably developed, that doesn't mean that someone has the right to say, well, you're taking my lot. If there's a reasonable development that can take place, that's what the permit process is for. If there's not, then there's nothing that says you haven't approved the lots. Remember, you're not approving lots in this context. You're writing a report to the Planning and Zoning Commission. They will act on the subdivision application after they give your report due consideration, but you're not approving lots. You're making comments about the subdivision.
Yeah, I have a comment. At our last inland wetlands meeting, just as we finished this project, we had a list of 2 to 3 items, such as like lot 6 is particularly challenging from the wetlands, and there were 2 others, I believe. And it was my impression, what we need to do is just send Planning and Zoning a short letter stating the 3 items that we mentioned.
That's perfectly appropriate. That's a report. You may want to add other things, you may not. What you don't want to say is that these lots are undevelopable. You can point out where the issues may exist in the future. You don't want to make a determination at this point in time that these lots cannot be developed. First of all, you don't have the information in front of you to be able to make that determination. Second, there's no application pending in front of you to conduct any regulated activity on those lots yet. So, but it's not inappropriate in your report to say there are going to be significant challenges on lot, 6, lot, whatever lots there are, based on the location of wetlands, based on, potential access issues in terms of crossing wetlands. That's not inappropriate at all to identify what those concerns are. You simply don't want to say permits will never be issued for these. They may never be, but you don't want to prejudge it and say that that's what our finding is going to be. So it's to give the Planning and Zoning Commission some idea of what the land is and how it might be able to be developed. Remember, a Planning and Zoning Commission has 3 options when a subdivision application is made to it. It can approve it, it can deny it, it can modify it. So, for example, I've seen an application in Wilton, for example, where it came to the Planning and Zoning, came to the Wetland Commission, and they said, in that case, we think this 7-lot subdivision should be a 4-lot subdivision because of all of the wetlands that are associated here. Now, it was just a comment, wasn't binding on the Planning and Zoning Commission. And as it turned out, in fact, it ended up being a 7-lot subdivision. But those were comments that the Wetland Agency made at the time that it was referred to them. They still then had jurisdiction over some of the activities that had to take place. And in fact, in that particular case, it hasn't even been resolved yet, what the developer is going to be able to do. He's got 7 lots. He may not be able to develop all 7 of them.
So I have a question, which is related to lot 6 and accessibility and going back to the prior application. So I realized that in that prior application, not only was there a wetland crossing to get to the buildable part of lot 6, but there was an extension of the road. But in this case, you can't get to the buildable part of lot 6 without crossing a wetland. So why is that not a regulated activity? Why couldn't they put that in as, why couldn't that be as in the previous time? Why isn't that an application? Because that is actually, I think, in our discussions has been a big sticking point.
Well, you're correct that wetland crossing is going to require a permit from or a review, from your agency. It's a regulated, if it's a regulated activity. The difference is, and this is going to seem a little bit, I don't know what the word is, but almost, playing with words, is that no application has been filed for that wetland crossing yet. It was filed the last time back in whatever year it was, 2010 or whenever. the property owner filed an application for a wetland crossing. I think but your report will say that no application's been filed, but an application will have to be filed to approve any wetland crossing, whether it's to lot 6 or any other lot for that matter. And, you haven't rendered a decision on that. I assume when you review a wetland crossing, for example, a road, you want to know materials, you want to have profiles of the road. You want to see exactly, are we talking about culverts? What are you talking? You want to know what the detail is in that particular crossing. You don't have that information in front of you yet. There's no application that's been filed. There's no doubt that one will have to be filed if the subdivision is ever approved, but it's not before you right now. But like I said, it's not inappropriate for your agency to report to the Planning and Zoning Commission that the subdivision contains a wetland crossing that we have not reviewed yet, and it's going to require our review. And the fact that they approve the lot doesn't mean that you have to approve the crossing. I think that's part of the issue that you're having. Well, if they approve the subdivision, do we have our hands tied? The answer to that is no. The answer to that is no. So, and the commission will give your report what we call due consideration. They may say, look, if this is going to require, a wetland crossing, we're not so sure that we want to approve this lot at this point in time. They could modify the plan, get rid of that lot, say, go apply for a permit. You want to re-subdivide it later, go apply for a permit, come back to us if you get a permit to do the wetland crossing. So there's all kinds of things that could happen.
Let me expand, give me just a minute. I want to expand on the thing I said before. There is a lot 5, that does not have access, not because of wetlands, but because adjacent properties won't give them an easement.
Right.
Should we mention that?
No, that's not a wetland related issue.
But if they did give him permission to carve out that lot, and they come along later and they want to do some extraordinary wetland filling, are we obligated to come up with a solution?
No.
Okay. But
You're obligated to review, at that point in time, David, you're obligated to review the application the same way you review every wetland application. And basically what your agency does when it's reviewing a wetland application is you're balancing the right of a property owner to develop with the impact on the wetlands. And if the impact on the wetlands is significant, that may mean that a property owner can't develop his property. If I go out tomorrow and buy 10 acres of swamp and go, pardon?
That's what this is.
Yeah, well, I have no guarantee that I'm ever going to be able to build on that. You have what you have, and the mere fact that it's gone through subdivision approval, that's just a division of land. Subdivision approval is a division of property. It's not, subdivision approval itself is not a regulated activity. A road is, things like that, but the subdivision itself is simply a division of land.
Okay, you've answered my question and I'm comfortable.
So
Good, thank
why is it though, going back to lot 6, why is it that when clearly in order to get that division, you have to have a wetland crossing, and previously they did have an inland wetlands application, why is that not part of it now? Like what is it that it seems a very fine line between saying there's a road or there's a crossing, and then you definitely need one when this referral comes through, and then this one where you clearly need to cross a wetland, you're in the wetland area, and there's not an application. Like,
Right.
what is that division?
Well, remember, it's up to the applicant to file an application. It's not, they chose not to do it. That means that they're going to have to do it eventually. They haven't done it yet. Now, the applicant may take the position, 10 years ago or whenever it was, the agency gave us a wetland permit for a crossing. And so we've already got a permit for that. But as you know, if circumstances have changed, if the wetlands are different, if the crossing's not in the same location, if there's any different circumstance now, if there's been a material change in circumstances, that permit only applies to that crossing for that subdivision. They would still have to come back to you to get a permit to do the crossing. If I suspect that I can't answer a question why the applicant did not file an application for a regulated activity, possibly because they didn't have the information they needed to do that yet. I don't know, but the law doesn't require them to make an application. The law says you can't do anything in that regulated activity, in that regulated area, until you do get a permit. And your report will point out maybe your report will say that wetland crossing to lot 6 is in a different location than it was in 2010. There are additional concerns that we may have with respect to that crossing, and you're going to let the Planning and Zoning Commission know exactly, what you think about that, and then they will act accordingly. Again, they get to decide what to do. After they read your report, they can do what you say. They can not do what you say. They can, it happens all the time. But it doesn't mean you've lost your jurisdiction down the road when there's a proposal to actually do something. The subdivision is not actually proposing to do anything. The subdivision is proposing to divide this property into 5 lots. So, which in and of itself is not a regulated activity, but down the road, clearly there will be regulated activity here, and your report will make that plain, I assume.
Yeah, on the presentation that we got 2 weeks ago, they showed location of the houses that they're proposing, but that's just someone's idea how they want to build it. What they're doing right now is just applying to divide the land, not to build the houses. That's what you're saying, correct?
Correct. Now, oftentimes a kind of a site development plan is put together with a subdivision so that the property owner can show that the lots can be developed. You have sufficient acreage and a sufficient location, and that's not binding on anybody. The subdivision doesn't approve those houses, doesn't approve the location of those houses. It simply approves the division of the land. So that's information that's really not necessary for purposes of a subdivision. And I don't think the regulations, and Dave can correct me if I'm wrong, I don't think the Madison subdivision regulations require site development plans to be filed, simply the subdivision map itself.
So we really don't know where the houses are going to be, or
Correct.
like the road on the lot that we've been talking about is actually going to be.
Correct. Or what it's going to be made out of, or, pervious or impervious materials, wood or metal, concrete, culverts. So you don't have any of that information in front of you, which is information you need to make an informed decision as to whether or not that crossing is going to have an adverse impact on the wetlands, or, can it be minimized through the use of, alternate materials or something. I mean, that's something that's not in front of you. It may be in front of you if that lot is ever approved in the subdivision process. If it's not, it may not come in front of you, but it's not, the timing of that is for later. And the purpose now, the reason that the statute exists is so that people who own property understand when they go to get a subdivision approved, that they have some issues that they're going to have to resolve with respect to individual development of these lots, that they're not free and clear, that they're not we got a subdivision approval. We have the absolute right to build 5 houses. That's not the case. Absolutely not the case.
Pete, it's Bob again. We're not also held to just these specific issues when these individual lots come back that we bring up in this report, correct?
No,
I mean,
correct.
okay. All right.
Absolutely. In fact, I mean, it's impossible for you to know right now what those issues are even going to be without a specific plan. I mean, there might be rain gardens, there might be detention basins, there might be a swimming pool, there might be, who knows? I mean, you don't even know what issues are going to come before you when these individual lots are developed yet.
Okay. Does the agency have any other questions? No.
Well, can you think we could get the gist of what we want to write in I guess it'd be a form of a letter to planning and zoning? Should we do this tonight? Because to me, it doesn't have to be complicated at all. It doesn't have to be very long.
It doesn't. It can be, like I said, whatever you decide it should be. The only effect that report, legal effect that report has right now is that the commission, Planning and Zoning Commission, can't render their decision until they get your report. Now, as I understand it, and Dave, you can correct me if I'm wrong, I don't think there's any time crunch with respect to their decision-making process for 2 reasons. They did this subdivision in a public hearing, so the public hearing timetable is in effect. If the applicant can grant extensions for up to 65 days for any of the 3 periods that cover public hearings, to open the hearing, to complete the hearing, and to make a decision. Those are the 3 time periods, and 65 days to open, 35 days to complete, 65 days to render a decision. Those individual, those 3 time periods can be extended for a total combined of 65 days. And right now, until the governor changes his executive order, there's another 90-day extension period that can be added onto that legally. So now again, and if an applicant doesn't agree typically to an extension, the Planning and Zoning Commission is left with a decision to deny an application without prejudice if they don't get a report from you within that time period, because the statute says they can't render a decision until that report is given. So, but I don't think that's a long way of saying, I don't think you need to draft that report tonight. You can, like I said, you don't think it's going to be very complicated. I don't know if everybody on the, on your board thinks that, but if you do and you want to send over, a short letter to the Planning and Zoning Commission, that will suffice.
Well, I guess, Tom, you think it's clear cut, or you have ideas. Does anybody, so I guess we could draft that. I don't know, Dave, I guess we didn't have an agenda for this, so I'm not sure. Anything else?
So the meeting was posted just with the same, I guess, agenda that was posted previously. So if you choose to go in the direction of providing a report, you could do that tonight if you choose to. And I would echo what Pete said. There's no statutory requirements holding us to the Planning and Zoning Commission meeting is scheduled for this Thursday. There's no statutory requirement that would, I guess, call us to have to vote on Thursday. But obviously, if you were prepared to provide a report, it would be in the interest of probably everybody to keep things moving. If you're not prepared to provide a report, I think that's an okay situation too.
All right. Well, I think why doesn't everybody, I mean, I think we should, for the agency members, you should, I think everyone should state um, what they think. I will review what we talked about last time, what we identified as problematical or challenging with respect to this application that we would cover in some potential future report to planning and zoning was the fact that inland wetlands delineation hasn't been done in over 10, 15 years. Things changed during that time. We definitely had identified lot 6, given that it's right through a wetlands and probably it is. It's through a freshwater wetland as well as a tidal wetland. Um, we talked a little bit about the open space division. I'm not sure that, I mean, we could talk about that some as well. And then I think what's been addressed tonight that also was mentioned as challenging were the access to the lots 4 and lots 5 because of easement and ownership issues, but that's not, it's not a wetland issue. The wetland issues are the delineation, the lack of current delineation that clearly, has undoubtedly changed, and lot 6. But
Well-
I'm happy to have people speak. Yes, Tom.
Last time you mentioned the fact that it's been at least 10 or 11 years since the wetlands have been looked at, and we don't know if there've been changes. That this is what you had mentioned last time.
Yeah, and this has come up in, yes, this came up, some of the lawyers had mentioned it, but, and I think Conservation Commission mentioned it in their letter as well. So it's been highlighted. Yes, I mentioned it, and I thought we talked about it last time as well, but I will mention it again. I personally think that having a delineation that old when wetlands are dynamic environments and clearly change over time, that's a problem. That's a challenge. That's a challenge to a future subdivision. And obviously the wetland crossing is as well. But this is why we have discussion. So if you guys would like to have a discussion tonight, we can. And I guess if we have a discussion we're comfortable with, we could collate that information and agree on it and move it along. But happy to hear from other people as well.
Well, I'm not gonna beat up on section 7.2, which says an application has to come here simply based on the fact that the land that's being subdivided as a proposal has wetlands on it. And the same language is in the subdivision regs. But it seems like the layout as shown is still in flux because per my notes, we have lot 5 having easement issues. Lot 6 crosses a wetland, and it sounds like we're opposed to that crossing as shown. And then later on in the meeting of the last wetland commission, the applicant side said maybe lot 4 and 5 will be undone. I do have question marks there, so I'm not sure if I heard it right. So it sounds like this is kind of like a nebulous subdivision plan. And I wouldn't favor crafting a letter tonight. I'd rather craft it at the next meeting. But I'm still hung up on the fact we don't have an application, but it sounds like Peter saying due to Judge Berger's past decisions, our regulations need to catch up and soften a little bit. But as of right now, I just feel like it sounds like the subdivision isn't in stone, and I'm just afraid of the Planning and Zoning Commission of approving 5 lots when the Wetlands Commission is going to come back and say, well, we favor 3, and then it's too late for us to. It's at some point it sounds like Wetlands P&Z is going to approve 5 lots when we really wanted 3.
Well, I guess, but I should clarify. I don't think, I mean, what I've mentioned with respect to lot 6 is not that it can't be done, just that it is a very challenging lot and it does have a crossing. I mean, it's directly in wetlands,
Mhm.
big wetlands. And I don't know, and I don't think, well, I'm not sure that we would recommend number of lots. I'm pretty sure that we shouldn't, but I think we just highlight. And I guess what you're saying is some of these lots are so problematical, it could go down to 3. And I guess that's what we highlight. We just highlight the challenges associated with these divisions. Okay, but I think what I'm hearing from you, Joe, is that you'd be more comfortable having a fuller discussion in March at our next meeting.
Yes.
So Bob, Lee, John, Dave, Nick,
I don't have any additional comments on the wetland issues, but I suggest that we take a shot at somebody, I think you volunteered last time, Kayla, taking a shot at drafting the letter before the next meeting, and then we can add to it and discuss it and do that sort of thing at the next meeting, because otherwise we're going to be kind of at the same spot then as we are now, I think. That's my comments.
yeah, I agree. I'd like to, we can keep moving. So Bob, I'm looking at people who haven't said, so Bob and Dave Newton and John, you 3 comments?
Oh,
I mean,
I would,
proceed. Go ahead,
go
John.
ahead. Well, I would recommend that we just send a general letter to planning and zoning as a subdivision referral, because as they do things, they're going to have to come back to us. But as our attorney says, there's a lot of information we don't even have now, so that we can't make specific recommendations. That's my opinion.
Honestly, I'm a little bit wavering. I'd love to get it done, and I just don't want to shortchange it. So I kind of like the idea of having some time to think about it, but I'm also in the middle of tax season, and I'm probably more challenged at this time of year than any other. So I could go either way on it. I could go either way.
All right, Dave Newton, let's hear from you. Then I'm keeping a tally in my head.
I think generally it could be a bullet type of setup, and I would like to see mention that most of the property is tidal wetlands rather than inland wetlands, so that they at least acknowledge that at planning and zoning. And I also would like to mention that there is questionable easements to access 2 of the lots. And just leave it at that. Let them ponder what that means and how they're going to react to it. That's my comment.
Okay, so I have, if I'm looking, I'm seeing 2 or 3 of us, not counting me, who are thinking we can maybe draft a letter, maybe get it. I don't know if we can do it by Thursday. And then several of us who are leaning towards drafting, probably still drafting a report or a letter and maybe reviewing it at our next meeting. So we can vote. We can pick one of those and vote properly. If someone is strongly in favor, or if Dave Anderson or John Delore want us to be strongly in favor of trying to push to get something drafted through in order to meet a Thursday meeting, you should say. Otherwise, we can vote. But I guess it seems to me, maybe I will draft something up and circulate it and get comments. And if it works, we could get it by Thursday. But people are time crunched.
Well, I don't have a preference either way. I want the agency to decide how to proceed. What I'd suggest, though, is that you make a decision tonight about how you're going to proceed and not leave it up to a maybe, because I think everybody on the call needs to have an expectation of what to expect. So if you,
No, I think we definitely need to do something. So does anybody,
I would think that just a memo saying, we have reviewed Longshore property and have a few areas that I think that the Planning and Zoning Commission should consider in their decision making, and just list them, then leave it at that. We don't have to get very philosophical. I mean, it's,
okay,
I agree with you, Dave.
so what I'll do, if you're gonna draft, not you, John. Here, look, if you're gonna draft something, what I will do tomorrow is I'll sit down and put the two concerns I have into two sentences, and I'll send it to you. And you can incorporate it or throw it away, whatever you want.
okay, well, I think we should vote on something
Okay.
to make, I imagine, because that gives us, and I'm not sure,
I think we should at least mention that we have concerns about impact on the wetlands. Just leave it. You don't get more specific than that.
okay, well, so I'm going to disagree with that. And so maybe we should vote. That's a totally vague, that's a completely vague statement, I think. And what our town attorney has suggested as well is that we can put into this report our specific concerns. And I think that's completely fine. And planning and zoning can decide whether or not they want to consider those concerns as they consider this application. So,
That's all right with me.
okay. All right, well,
I'm sorry for interrupting, but, and I guess I'd like to get Peter's kind of thought. Is it procedurally okay for us to submit some of our concerns and have Keola kind of champion it and put together like a master list of what she probably feels is appropriate and send it out to everybody and everybody kind of votes on it? Or is it something that we have to do in a meeting?
Have to vote on it in a meeting, unfortunately.
In a meeting. Okay.
You could call a special meeting. You only need 24 hours notice to do that. So you could, for example, have a report circulated and now is it going to happen before Thursday? I doubt it. I don't know how it could happen before the Planning and Zoning Commission meets on Thursday. So but forgetting the time crunch for a second, procedurally, the better way to handle this is to have somebody draft a report and send it around to the members to review, and then vote on it and discuss it and vote on it at the next meeting. I would just say that is the simplest way to come to a consensus. Otherwise, unless you want to sit tonight and somebody takes notes and says, here are the concerns, what does everybody think? And take a vote on each one of those points, and then it can be put into a report and sent to the P&Z. If you want to do that tonight, it might not be that difficult. There might not be that many things that you need to say in the report. I don't know, but in an ideal world, I would have the report drafted, sent to everybody, and then people can make their comments on it. Now that, not taking into account the fact that there's a Planning and Zoning Commission meeting Thursday night and everybody wants to, get moving on this. And I understand that. But if you're gonna issue a report as a commission, it ought to be something that the majority of you agree on.
okay. So I think we're left with, we stay on and hash out a report and try to vote on this tonight. Or I will draft something and send something around tomorrow, and you look at it, you comment on it, and we address this at our next meeting.
Now, is the public hearing still open in front of P&Z?
Yes.
Yes.
And during these dark times, there's no 65, 35, 65. There's no pressure to have something in front of them on Thursday.
Well, there are 65, 35, 65, but there's also an additional 90 days plus 65 days of extensions. The applicant needs to agree to those. That's not something that the town controls. That's up to the applicant to agree to that. But if, assuming the applicant agrees to that, there's no time pressure right now. It doesn't have to be decided. And Dave, you're probably keeping track of the time.
Yeah, so this would be, the planning and zoning meeting would be the second hearing. So we continued it from the last meeting. So let's say it's 30 days now that the public hearing's been open. So if it's going to get pushed to our next meeting, we would need the applicant to, I guess, concede to an extension.
Right.
But isn't there an executive order which does away with the timeframes for now until at least March?
No, there's an additional extension of 90 days. But it's not, doesn't do away with the time limits. It just, and again, that 90 days is treated the same way the 65 days of extensions are treated. It's not up to the agency and the commission to do that. It's with the consent of the applicant.
Okay.
But the applicant has every reason to agree to extend, because if they don't, and they're running out of time, the Planning and Zoning Commission is going to have to deny it without prejudice, because even though they don't have a report from you, so they can't act on that, but they've run out of time. So.
Okay, so I think in the interest of time, I think maybe someone can, I think we need to vote on which direction we're going to go. Are we going to stay tonight, or we need to decide if we're going to stay on tonight, or I will draft something.
I'll make a motion that we actually have Keola draft something, that we all comment on it, and then we push it to the next meeting.
I second that motion.
Right, any discussion? Anybody want to contest that, push that back? Okay, all right, all in favor of the motion?
Aye.
Aye.
Aye. Okay, all right, well, nice to have a decision. I will do this. I actually will work on it tonight. I've been taking notes. I will send this around. And I know our next meeting is coming up probably in just a couple weeks. This is a short month. So I'll get this sent around. And I know, people have a lot of comments and thoughts on this. So this at least will give us a chance to, to get your thoughts out there. And we'll have, we won't make it a long thing, but we'll get something to planning and zoning that we can all feel comfortable with.
Okay.
Okay. So Dave, anything else? I know we have other people on the line.
No, I think that's it. I think that's it for tonight. This is a special meeting, so we can't add anything else to the agenda.
Okay. Okay. Well, it was good seeing you guys mid-month. And I'll be emailing you, and I'll see you again soon.
Thank you. Thanks,
Good night,
everybody.
Thank you. All right. Thanks,
night.
Mr. Gelman.
My pleasure.